Hi, I'm Liz Naumovski, host of Finance is Personal. Life isn't as traditional as it used to be. More and more couples are choosing to live together rather than get married, and many are entering relationships without thinking about the commitments that they're actually making. And even though they are entering these relationships in a very non-traditional way, when you decide to leave, you actually get out in a very traditional way. So today's show is about important information regarding cohabitation, separation, and divorce, including a lot of the questions that come up afterwards and common misperceptions. And joining me to discuss cohabitation, separation, and divorce is Georgina Carson, partner with MacDonald Partners LLP. Welcome to the show.
Thank you.
You know, I can't believe when I was prepping the show, I actually found an old show that you and I did an interview back 19 years ago. And it was so funny because I remember doing the show. I didn't remember the guests or anything, but I remembered the guest was fantastic.
Oh.
So I'm so happy that you're here today.
Oh, thank you. Thank you for inviting me.
Now, when people move in together, how long before they're considered common law?
Well, that is a very good question because the term common law is not actually a legal definition, but we all use it. It's
Right.
a very common colloquial expression. But the actual sort of legal term is unmarried spouse or spouse. The definition of spouse has different definitions in different pieces of legislation. For example, in the Income Tax Act, if you live together for just 1 year, you're considered spouses. So that can have effects for principal residence designations and other factors. Under the Family Law Act, there's, just to be confusing, there are two different sections with two different definitions of spouse. So under the support provisions, if you live with someone for 3 years, and that's 3 years is a common number that people think of with respect to common law. If you live together for 3 years, then you're entitled to claim spousal support. But interestingly enough, that period collapses if you have a child together. But with respect to property and an equalization of net family property, there is no period of time that one lives together that you ever become entitled to seek a property division. In Ontario, it is different in other provinces, so you have to be very careful about where you're living. But in Ontario, you could live with someone for 20 years and never be entitled to an equalization of net family property, which is a common misperception because sometimes people think the minute you move in together, the other person is entitled to half your stuff, as it were. And that's not true. And it's not even true after years and years and years. So that's a very good thing to point out.
You know, there are so many misperceptions. A lot of people think, as you said, if you are cohabitating, you automatically get half. And that's why we're doing this show today. So when people move in together, what are the financial implications if you are an unmarried spouse? And then what are the differences in rights and responsibilities from being a married spouse? Because those are two completely different things.
Well, child support is the same. In fact, you don't even have to live together. If you're the parents of a child, then the child has the right to support. With respect to spousal support, it's the same after 3 years, or if you have a child together. But property can be very different. For unmarried spouses in Ontario, they do not have the right to seek an equalization of net family property. But if they live together for a long time and finances become quite intertwined, and maybe they've made contributions to a property, a house, or a business, we have now developed over time what are called equitable claims. So people could make a claim for unjust enrichment and resulting trust. And in the past decade or so, there's been this concept of joint family venture, which makes sense. If a couple has together built a business or built a house or renovated a house and both have put money into it, that could be considered a joint family venture. But the problem with these equitable claims is they're not they're not set out in writing. They're not in a statute. They're not in legislation. So they're very discretionary, and they can be quite complicated. So I sometimes I laugh when someone comes in and says to me, "Well, I'm an unmarried spouse. I want to have I want to separate from my spouse, but things will be really simple."
They're never simple
because I'm unmarried, and that sadly is not. Sometimes it's far more complicated when people are unmarried. Partly because people have very different expectations. Often when people get married, it's a very conscious commitment, but sometimes people get into unmarried relationships where they have wildly different expectations. One person may think, as you've pointed out, that they're entitled to share in everything, and the other spouse may think they have no obligations, and so both are usually wrong.
And the problem is, things are great when you're getting along and you're in love, quote unquote, but then when things start turning sour, it's really, really difficult because everyone has their own preconceived notions, and everyone thinks they're entitled to everything or not entitled to anything. And then it just becomes awful. So this leads me to the next question, date of separation.
It's a very important date especially for married spouses who are going to be dividing their property or engaging in an equalization of net family property, because that's the date on which all assets and debts are crystallized for determining net family property. But it's also an important date for unmarried spouses in figuring out how long they've been cohabiting. And the date of cohabitation is important. The date of marriage is usually not in dispute, although you'd be surprised. Sometimes people have religious marriages, and some people have civil ceremonies, and sometimes they don't actually. They might have a big party, and people think they're married, but they're not really married. Anyway, that's sort of another kettle of fish.
So it gets complicated.
But the date of cohabitation, people can, often, especially in this day and age, people may have two homes, they have two homes, but they spend a lot of time together, and it's almost seamless, it's organic. They start to cohabit, and it's not even clear. Interestingly enough, even the date of separation can be really unclear, because people often continue to live separate and apart in the same home, especially if they have children.
Right.
And they don't want to jeopardize their rights, and they want to move forward, but they're essentially leading separate lives. And so when these dates are in dispute, it can lead to a lot of controversy in resolving the issues. I had a case once where there was a dispute of 10 years of the date of separation. One spouse said they separated 10 years earlier than the other spouse.
Oh, wow.
So that was complicated.
So that date is extremely relevant.
And so is the date of cohabitation, because even for married spouses, the date of cohabitation is when the clock starts ticking for spousal support entitlement. And so I also had a case once where the wife claimed that they'd been cohabiting since they were 18 because they'd visited each other's dorm room at college. And if she'd been successful in that claim, which she wasn't, then it would have actually pushed her entitlement into a substantially higher potential amount of spousal support. So people sometimes come up with these crazy revisionist ideas about their relationship, unfortunately.
Okay, so as unromantic as this is, cohabitation agreements, marriage contracts, it used to be a taboo years ago. If you put together a marriage contract, it's because you were marrying a gold digger, and there was so much stigma attached to it. But now, it seems like the right thing to do.
Well, they're quite common. They're quite common for people entering into a second marriage or a second long-term relationship, or people with substantial net worth. Often, when I have younger people coming to me, it's often their parents or their grandparents who are pushing them. But for more mature people who are entering into a second relationship, they've often established their own careers and their own lives, and they have children from previous relationships. And so they often come in and just want, they want to continue in their romantic relationship, but they want it clear that they have separate regimes of property. It's the sort of what's mine is mine and what's yours is yours. And that's those are the simplest agreements, actually, and there's nothing, there's nothing unsavory about that. Back in the day when, a 55-year-old wealthy gentleman was marrying an 18-year-old naive young woman who, and a week before the wedding, he says, sign this or the 400 people coming to the wedding are going to be disinvited.
Right.
Those sorts of contracts, mercifully, are few and far between, and you'll be glad to know, routinely set aside.
I still can't believe that there were actually contracts that were set up like that, you know, a week before the wedding, a day before the wedding or whatever, and it was all coercive and under a lot of pressure. So when's the best time to come up with one of these prenup?
Well, if people are actually, doing a prenuptial agreement, which we also call a marriage contract, in anticipation of a pending marriage, the sooner the better. In fact, if someone comes in to see me, I say, please don't book the wedding date until we've worked forward, because they sound simple, but even, or I shouldn't say even, especially with marriage contracts and separation agreements, financial disclosure is so important, and they are regularly set aside if that important standard isn't met. So it isn't the contract itself necessarily that takes the time, but people, if they have complicated trusts or corporations, and again, if it's the second generation or the generation above that's encouraging the contract, there is often a lot of disclosure that's necessary, and also to your point, to get away from what may be perceived as pressure or duress, or because in family law that the standard is, and understandably, it's somewhat less than the traditional, someone had a gun to your head kind of coercion. I mean, there's a lot of pressure sometimes in a relationship that can lead to someone signing a contract that is clearly contrary to their interests.
So Georgina and I will be right back after the break to discuss more on cohabitation, separation, and divorce here on Finance is Personal. Hi, welcome back to Finance is Personal. I'm Liz Naumovski, and today we're discussing cohabitation, separation, and divorce. Joining me to discuss this is Georgina Carson, partner with MacDonald Partners LLP. And before we went to break, we were talking about financials for a cohabitation or a prenuptial agreement. And what do you do when somebody either embellishes what their finances are, or if they start hiding assets? Like, how does that affect the cohabitation or prenuptial agreement?
Well, certainly I make it very clear to my clients that they must make full and accurate financial disclosure, and that they it's up to a lawyer to cross-examine if there's any suggestion that something hasn't been properly disclosed, and right from the get-go, make it really, really clear that they are imperiling themselves and the validity of the contract if they don't make full and fair and frank disclosure. And you really have to ask a lot of questions. Is anybody holding property in trust for you or for your benefit? Or, is there, do you have any assets outside of the country? I find that most people do not purposely, not disclose something. They just forget, or they estimate. And estimates can be wildly inaccurate, right? I mean, they think that they're giving an accurate calculation, or an asset itself is forgotten. Maybe their great Aunt Muriel had set up an account in their name when they were in their teens, and there may not be a lot of value in the account, or there might be, and they've just forgotten. So, especially I find with, and this is a really interesting aspect actually, is that when someone, relatively young comes in and they're getting pressure from their own parents or grandparents to have a marriage contract, they have no idea about their finances, and sometimes they have not been told. Sometimes they don't even know that they're beneficiary. They may know that they're a beneficiary of a trust, but they have no idea what the assets of the trust are. And sometimes, notwithstanding the pressure to do a contract, the parents don't necessarily want the child to know. So, it has to be very clear that there has to be transparency and full and open disclosure. And frankly, I think that's wise for anybody getting married, is to have a really good sense of what the other spouse has. Recently I had a case where the parties had been together for years and years and years. They finally got married, and only about 6 months after marriage did the wife learn that her husband was actually a terrible gambling addict, and she had no idea, and it had never been disclosed. And he had misled her. They didn't have a contract at that time. But, I think it's really important for everybody to be transparent about their finances if they're going to be cohabiting with somebody.
I think the other key thing too is when you have, two spouses, you need two separate lawyers as well. Because I think a lot of people just assume that I'll just pick one lawyer, my spouse will go to the lawyer, and we'll just get it done with the one person, not realizing that you actually need two separate entities to take care of you.
That's right. And especially, and it can be quite delicate with respect to a cohabitation agreement or marriage contract, because these are two people who are clearly in love, they're cohabiting, they're talking about potentially getting married. And so it's hard to make it clear to them that technically they're adverse in interest when it comes to the contract. And what I don't like about cohabitation agreements and marriage contracts is that we're crystal ball gazing. We're looking into the future and we're trying to speculate about what might happen, what the circumstances may be when and if that party separates or dies. Because the other important fact to remember is that most cohabitation agreements or prenuptial agreements are not only triggered by separation, but by death.
By death.
So people have to be really careful in remembering that they could be happily married,
right.
And this contract is going to govern their rights. Now, virtually every cohabitation agreement or marriage contract has a provision that says that the person's will govern or will, so most people, of course, if they're happily married or cohabiting, will make provision for their more generous provision, usually in their will for the spouse. But the other spouse has to be, both spouses have to be vigilant, about remembering that the prenuptial agreement, marriage contract, or cohabitation agreement exists, and making sure that they have a valid will, because they may have forgotten about it, or they may, or their will may, a lot of people think, I'll get around to doing a will, I'll get around to, and then something horrible happens, like they get Alzheimer's, or they, so
an accident, something.
Exactly.
Yeah.
You can never predict. And that's where things can happen that's unexpected. But back to the unsavory nature of the cohabitation agreement or marriage contract, a lot of people, don't even want to think. They don't want to think about the possibility of separation. And I think, but that's why you're here. That's why you've consulted lawyers to it's really important to get the lay of the land about the laws that would affect parties if they do separate, and that's not a bad thing in and of itself. I have a lot of people who come to me and they say, well, I'm going into a second marriage. I've built quite a nest egg for myself, and I want to protect that. And I say, oh, well, that's great, because the law actually provides you that protection already, because under the Family Law Act, when you get married, you are entitled to a date of marriage deduction for the value of everything you bring in. Now, there are exceptions, including a matrimonial home, which if it exists at the date of separation. But a lot of people are just relieved. Like, they're relieved to recognize that, in fact, they don't have to go out of their way to do a contract, because they're quite happy to share in the growth during the relationship. But they just want credit, for what they've brought in. And that's understandable.
And you know what? They're not that difficult to put together. It's not that difficult to put your finances together and figure out what you own, what your home is worth, what your car is worth, or whatever. So it's not that onerous on people.
And it's not a bad idea to do anyways.
I agree.
I think it's good to take stock.
And you know what? I think it's great when you're getting along, you're actually enjoying each other's company, and you're actually rational. Because I think you've got to be extremely rational in order to put down, this is what I own, this is what I brought to the table, this is what you own. I don't want your stuff, I want my stuff. And I think when you do it at the very, very beginning, and actually, when should somebody put together a prenup?
Well, ASAP if they're planning to get married, because what happens is everyone gets busy, and you don't want to have a circumstance where you're trying to sign something, the week before a wedding, because it's just an uncomfortable thing to have to do. And it could also invoke allegations later on that there was that undue pressure or coercion or duress at the last minute. And you'd never want to, you want to have, everybody wants to have a valid contract. That may change down the road if one party decides it's unfair down the road. But certainly you don't go into a contract anticipating that it's not going to be valid. And so you want it to be valid. But, the good thing about cohabitation agreements and marriage contracts, to your point, is that people their expectations are aligned, and that's not a bad thing, right? Because I think a lot of people enter into marriages, unmarried relationships, with quite different expectations, and you'd be surprised at how often those things are not discussed between spouses.
Oh no, I totally agree with you, and that's why we're doing this show. And we'll be right back after this break to talk more about options and steps for resolving issues arising from a relationship breakdown here on Finances Personal. Welcome back to Finances Personal. I'm Liz Naumovski, and today we're discussing cohabitation, separation, and divorce. And joining me to discuss this is Georgina Carson, partner with MacDonald Partners LLP. It's funny, there are so many people that are afraid to talk about things as couples, whether it's a cohabitation agreement, their finances, children. There's so many things. And my next question to you is engagements. People talk about engagements and then they plan these incredible weddings or whatever. Once you're engaged, what rights do you have?
Well, that is a very, very good question. So people don't accrue sort of family law rights in the sense of, rights to support or rights to an equalization of net family property. But occasionally, and it depends on the circumstances, but occasionally there are situations where, a wedding is called off sort of right before the wedding day, and there's damages that arise from the costs that have been lost. So that's more of it's almost like a civil claim. It's not so much a family law claim, but it's more specific to the actual loss. And, sometimes people ask for damages for pain and suffering and things like that. That's pretty hard to make out. But the actual rights that would accrue to a married spouse do not apply to an engaged spouse. And the interesting thing about something like an engagement ring is sometimes the person who gave the ring wants it back. Mm-hmm. It may have been a family heirloom or something like that. And but and if the person, if it was the woman who got the ring who called off the engagement, then that may not be an unreasonable thing to do. But technically, once that gift is made, because it is a gift, that's the person. It's the recipient's asset. And interestingly enough, when you get married, and if there's a separation later on, people find this kind of counterintuitive, but it's the person, you're entitled to a date of marriage deduction for the ring, the person who got the ring. So not the person who gave the ring and paid the money, but the person who received the ring, they actually are able to deduct that as a date of marriage asset. Now, often they still have it, of course, at the date of separation, so it ends up being maybe a wash in the calculations. But I've had many, many givers of rings say to me, but that's unfair. I paid the money for the ring. Why is my spouse getting that deduction?
So which turns me full circle. I've been reading so many different articles about this is how you bulletproof your prenup or bulletproofing your cohabitation agreement. And it's so sensationalized. And I'm wondering, is there such a thing as bulletproofing? I mean, the agreement is an agreement.
That's right. A contract is a contract, and it used to be, and things have changed a lot, but it used to be in family law, a contract is a contract. Until
something different happens.
But I mean, the good thing is, and again, it comes back to certainty and validity and whatnot, is that more and more often contracts are being enforced and held up, and it's but there are some real foundations to that need to be met, and one of them, and the most important requirement to have a binding domestic contract, which can be a cohabitation agreement, marriage contract, or separation agreement, is financial disclosure. Mm-hmm. There needs to be full and a frank and fair financial disclosure in order to have a binding contract. So sometimes, and you fast forward 20 years and you look back and say, well, wait a minute, at the date of marriage when we did this, or before the date of marriage when we did this contract, you didn't give me full disclosure with respect to your family's business. The irony is at the time, it may not have even been requested, but it's really important in family law to know that there's a positive obligation to make financial disclosure. It's not like other areas, say you're buying a business and, it's up to you to do your due diligence and make sure that you get the information, and it's buyer beware. In family law, there is a positive obligation. It's a fiduciary duty, really, for both spouses to make full disclosure to the other, both at the time of an initial contract and ultimately at the time of separation. So I can't emphasize enough. I would say that if a contract is set aside, that the majority of times is because something hasn't been disclosed.
And that's really important. That's one of the things that we talk about, and it's a theme of the show. A lot of people are afraid to talk about financial disclosure.
Mm-hmm.
People,
Mm-hmm.
I mean, it used to be taboo. Parents would not talk to you about finance. Spouses didn't talk to each other about finance. If you're engaged to someone or cohabitating, things are separate. And that, that's extremely important, and people seem to forget about that.
Mm-hmm.
Now, my next question to you is sweat equity. Explain what it is, because I've read about it, but I really haven't heard it that often.
So sweat equity is something where someone puts a lot of work into something, and or sometimes money and work, but it often comes up in unmarried spouses cases where someone is making an equitable claim or a trust claim. So they're saying, okay, we had a joint family venture, and I put all this work into building this house or maintaining this house or a business, and so even though they don't have necessarily statutory rights to share in it, they're going to court and saying, well, wait a minute, I had the boots on the ground, I put in all my blood, sweat, and tears into this business. And so that's where a lot of unmarried spouses are able to basically assert property rights.
Oh, so that would be, one of your spouses that would be painting inside the house or regrouting or fixing floors or whatever. And if they don't own the home, through the sweat equity, they have some sort of a portion of your home.
That's right. That's called constructive trust remedy. And if they've put money in as well, that may be resulting trust, or you get into circumstances where there's unjust enrichment, and those are the kinds of words and claims that are made. Yeah.
So I want to talk about children. There are so many families that are getting together right now, and there's 2 children from, his side, 2 children from her side. You've got all these melded families. And what happens when the family breaks down? And who's responsible for spousal and for child support?
Well, that is a very good question as well, because we live in the age of melded families and Brady Bunch kids.
Yeah, and that was so weird back then.
Yeah, exactly. And now it's de rigueur. And so what happens on separation is that a child may be entitled to support from more than 2 parents. That child may be entitled to support from 3 parents, because the step parent may have acted what we call in loco parentis, which means in the feet of the parents, or in the position of the parents. And so they may owe support for that child, even though the biological father or mother may still be around. And particularly if a step parent has been quite involved and made financial contributions to this child, which, it's interesting, because I think it sort of falls into the category of no good deed goes unpunished,
right.
Because the more you take on a child and treat them as your own, the more there may be obligations on relationship breakdown. Yeah.
And a lot of people, I don't think, realize that. I think they realize it's the same thing as, if you bring in your home and your properties, you brought in your children, you take your children. But
that's often what happens, but there are these cases where someone has an obligation.
So when parties separate, how's parenting determined then?
So the only factor that is supposed to go into the determination of parenting arrangements is the best interests of the child. But of course, that is a very, well, it's not that it's unclear, it's just
it's different for every family.
Exactly. And people look at it through different lenses,
right.
So both parties generally say, well, my proposal is in the best interest of the child, and it can be very hard to settle parenting.
Okay, so my last question to you is, upon separation, and this is long, so I'm going to read it, what are the options and the steps for resolving the issues arising from a relationship breakdown? If you can just go through it.
Sure. So the first thing is that people should immediately get family law advice from a family law lawyer, a lawyer who practices in family law, and because they need to know the lay of the land immediately. Because sometimes what happens is people say, okay, we're separated, let's sell the house, and the house may be in one party's name, and then they split the proceeds, and things can go sideways pretty quickly. Also, there are rights that can be suspended right away. If someone moves out of the home and there's children, that person may have suspended their custody rights, and so it's really important to get legal advice right away. Then the financial disclosure, which we discussed, and many people then negotiate. You'll be glad to know, many people then negotiate a cooperative, amicable separation agreement. If people come to an impasse, then an option is alternative dispute resolution, which could be mediation, which could be mediation arbitration. In the negotiation phase, sometimes people engage in a collaborative practice where they sign a participation agreement saying, we are going to settle this, and if we don't, we have to get new lawyers. So there's a real incentive to come to an agreement. And the good news is that most people try to avoid court. Court is a blunt instrument. It is not designed to, it is not the best outcome for families to have an independent judge who knows nothing about the day-to-day intricacies of the family, make decisions about parenting or other issues. So, and even if the matter does go to court, in Ontario we have a family law system that itself is very settlement-oriented. So there's lots of case conferences and settlement conferences where the judges really try to help people settle their cases. So 95% of matters settle before ever getting to trial, which would be, which is a horrible and devastating financial and emotional event for a family. There are cases where court is necessary, if a child's being abducted and, or there's threat of abduction, or if there is, someone is dissipating their assets or failing to make disclosure. But those are really the cases that demand court intervention. But most people are able to settle their issues through an alternative form of dispute resolution and resolve their issues cooperatively.
That's so good to hear. Thank you so much, Georgina.
You're welcome.
Whether you're cohabitating or married, make sure that you protect your finances and assets before you move in or sign the marriage license. Talk to your partner or future spouse about what happens to the assets if you do break up in the future. And it's better to talk about these things when you're getting along and enjoying each other's company, rather than when emotions are high and there's no way to discuss things rationally. I'd like to thank Georgina Carson for joining me today, and you, our viewers, for watching. I'm Liz Naumovski. Bye for now.